Breaking news and huge favorable news in favor of the Second Amendment. The United States Court of Appeals for the Fifth Circuit out of Texas and Louisiana has found that federal criminal statute 18 U.S.C. 922 G8 is unconstitutional under the Second Amendment and NYSRPA versus Bruen. This is a major win for the right to keep and bear arms. Stay tuned. We'll go over it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you haven't subscribed to the Four Boxes Down Second Amendment channel, please do so. Help us with the social media algorithm. We're trying to hit 100,000 subscribers. Huge breaking news, great news, another major win for the Second Amendment's right to keep and bear arms. The United States Court of Appeals, a federal appellate court, has applied and ruled in favor of the Second Amendment's right to keep and bear arms under NYSRPA versus Bruen, declaring that a major part of a federal gun control law, specifically 18 U.S.C. 922 G8, which deals with prohibited people, specifically Section 8, deals with individuals who possess firearms at the same time they are subject to a restraining order. Now, you know and I know that oftentimes restraining orders are entered into civil cases like divorce proceedings with no findings of fact about whether or not somebody's a problem or not. And that's basically what the Fifth Circuit said. But let me be very specific here. This is a huge victory for anyone that's interested in the nonviolent felon case, including, for example, the Range versus United States case, which is going to be heard en banc in just a few weeks, I believe, with oral argument, whether or not nonviolent felons lose their gun rights forever if they are convicted of a felony, even though they're nonviolent. People like Martha Stewart, whether or not under the Second Amendment they can be deprived of their gun rights forever based on the historical precedent and the historical tradition of gun regulation to the extent it existed at the time of our founding. Now, specifically what happened here in this case of United States versus Rahimi, he was convicted of possessing firearms at the same time he was subject to a civil restraining order arising, I believe, from either an ex-spouse or an ex-girlfriend. I'm not sure which it was. But the bottom line is there was a restraining order saying he couldn't go near his ex, and he was caught in possession of firearms while this restraining order was in place. He was convicted under 18 U.S.C. 922 G for possession of a firearm in violation of while being a prohibited person. And he challenged his conviction. His conviction was actually upheld, but that was upheld under the pre-NYSRPA versus Bruen standard, which is a totally different standard. In light of NYSRPA versus Bruen, the Fifth Circuit Court of Appeals took another look at Mr. Rahimi's case and concluded that indeed it is unconstitutional under the Second Amendment to deny people their Second Amendment rights merely because they are subject to a civil restraining order. Specifically, this is what the Fifth Circuit Court of Appeals panel said. It was a three-judge panel. It was unanimous 3-0 in favor of the Second Amendment. This is what they said. This is very important. The Fifth Circuit Court of Appeals said that Justice Barrett's dissent when she was a judge in the case of Cantor versus Barr, and Judge Thomas Hardiman, a prominent Third Circuit judge overseeing the Range case coming up, that their views, Barrett's in the case of Cantor versus Barr in dissent, and Judge Hardiman's view in a case called Binder Up, okay, that is correct. Because those views said that Americans, all Americans, fall within the definition of people. Specifically, the Fifth Circuit said, quote, the government's argument that Mr. Rahimi falls outside the community covered by the Second Amendment rests on the first approach, meaning that if you're convicted of a felony under any circumstances or you're viewed as a bad person, you don't get your gun rights forever. But then the court goes on to say that we think that that interpretation of just taking away people's gun rights because they violate some law in and of itself is simply not the proper one. We think that Barrett's decision and Hardiman's decision that there has to be some showing of dangerous is the proper view. Specifically, and this is very important, listen to this very carefully. The Fifth Circuit said specifically the following dangers would bind into the government's argument that they get to define who is a felon and who should not be allowed to have gun rights. Here is why. Very powerful argument here by the Fifth Circuit. Quote, perhaps most importantly, the government's proffered interpretation lacks any true limiting principle. any true limiting principle, meaning it can go on and on and on. Here's what the Fifth Circuit continues on and says. Under the government's reading, Congress could remove unordinary or irresponsible or non-law-abiding people, however expediently defined, meaning they can just label anyone, right, from the scope of the Second Amendment. And then they go give examples. This is not me. This is the Fifth Circuit Court of Appeals, a federal appellate court, in a ruling today, which I'll link to down below. They asked the following, quote, could speeders be stripped of their right to keep and bear arms? Political nonconformists, people who do not recycle or drive an electric vehicle. One easily gets the point. Neither the Heller nor Bruen decisions contemplate such a malleable scope of the Second Amendment's protections. To the contrary, the Supreme Court has made clear that the Second Amendment right is exercised individually and belongs to all Americans. It goes on to say that although Mr. Rahimi is not a model citizen, which appears to be true based on the record, he is nonetheless part of the political community entitled to the Second Amendment's guarantees, among other things. By the way, this court goes into a detailed historical analysis. They look at historical laws, in England, a colonial time period, so-called surety laws, and they said that none of these things are appropriate historical analogs to justify taking away gun rights merely because someone is subject to a civil restraining order, which I think is the right legal answer. Let me conclude. The language from Judge James Ho in a concurrence is extremely powerful, and I want you to remember this. Very powerful. He signed on to the majority opinion entirely, which is great, but then he goes on and writes the following as a separate, very short concurrence. This is what he writes. He talks about how the citizen and the government work hand in hand to prevent violence and to protect civil society. Here's what Judge Ho writes, Fifth Circuit Court of Appeals. Quote, in sum, our founders envisioned a nation in which citizens and sovereign alike play important roles in protecting the innocent against violent criminals. Our decision today is consistent with that vision. Therefore, I concur. Period, close quote. Judge James Ho, Fifth Circuit Court of Appeals, again, 18 U.S.C. 922 G8, declared unconstitutional by a federal appellate court, claiming it violates the Second Amendment's right to keep and bear arms, a powerful bit of that, further powerful evidence that the NYSRPA versus Bruen decision is being respected by the inferior, lower courts in the United States, and that this means and bodes well for our right to keep and bear arms and our freedoms under the Constitution. Okay, folks, hope you learned a little bit something here today about this breaking news. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.